Gideon Rozner here from the IPA, reporting on day 3 of the peterridd case at the Federal Circuit Court in Brisbane, in what has been another explosive day for this important fight for free speech on climate change. Now, the day began with a continuation of the defence's closing argument, which is where we left off yesterday, where Chris Murdoch QC, the barrister acting for JCU, continued to try to justify the railroading of peterridd by the university. Now, the judge didn't seem particularly receptive to that. Judge Vasta questioning in particular things like the direction that was given to peterridd at one point not to speak to anybody about what he was going through, including his own wife, something that the judge seemed to have a lot of trouble with, and that Chris Murdoch acting for JCU in particular seemed to have a very difficult time justifying. It was also noted that Professor Hughes, who was the academic from JCU who originally lodged the complaint against peterridd for his comments on the Great Barrier Reef science, used that language that was very, very similar to peterridd and that was used to justify peterridd sacking, yet no disciplinary action was taken against him. So it was very, very important to note the double standard and the selective nature with which JCU applied their own code of conduct. Following the close of the respondent's case, we went back to the applicant's case, and Stuart Wood QC, who is the lead barrister acting for peterridd, delivered an absolutely masterful closing argument, really going to the heart of what this case is about. Firstly, he went through a wealth of common law that established intellectual freedom as something that is fundamental to academia. It's what he called an ancient right that's enshrined in common law and absolutely indispensable for what a university is supposed to do. But not only does academic freedom, as Stuart would put it, protect what you say, it also protects how you say it. It doesn't matter, for example, if peterridd's comments about the quality of science coming out of James Cook University were insulting to his colleagues, as JCU alleges. It doesn't matter if they were pejorative. It doesn't matter if they were satirical. All that matters is that they were honestly held opinions, and that is the point that Mr. Wood put very, very effectively to the judge and to the court. So this case is expected to wrap up today, after which time the court will adjourn and Judge Vasta will go and consider the arguments and hand down a decision expected to be sometime within the next few months. But regardless of the outcome, everybody involved in this fight for freedom of speech has to be commended for the work they've done. Of course, Peter's legal team, led by Stuart Wood, but also joined by Ben Kidston, Ben Jealous, peterridd himself for having the courage not to take the university's disciplinary process lying down, but challenge it, and of course the thousands of people who donated to Peter's legal fund, which was needed to bring this action against a very, very well-resourced university. If you are interested in Peter's ongoing fight for freedom of speech on climate change, please do head to ipa.org.au/peterridd.